As well for everything.
Good. Yeah, they gave us this one that's there.
Wait, since my trouble is it's inside. No, it's edible. It doesn't have to be outside. So it doesn't have to be outside. Yeah, I don't. Yeah, I know. It shows nutrition. You don't have to factor out those things. Yes, you do. You're like I am. You got the phone. It's sort of like oh no, I so yeah, it's weird conversation, no, you're good. I said okay. I don't understand you. When I was teaching this guy is there's people house. I know, right? Sometimes it's like you want to why? So far, I have my arm is very good. No, they won't. Yeah. It's going to be something forever. I have to pay something.
Right, yeah, you got contingency plan. Yeah, yeah.
Oh, that would be more.
There'll be a fundraiser. Rough, it's hard. Yes. I think it's, I had one. I can go to the record center. Actually, I have some rum. I got rum, I got whiskey. What's it? Yeah, I was gonna say.
There's the magic.
Like an introduction first? Oh, there's Dr. Mark.
Dr. Marsh.
We're going to record this, right?
Yeah.
All right. Are you ready? We're starting right now?
I am.
All right. Let me get recorded and then we'll record already.
Is a microphone?
This looks like one right here.
There's a microphone?
I think this is one right here, right? Or is that just a, this looks like it has a microphone on top. Alex,
Good afternoon. Good afternoon, everybody. I apologize for the late start. I am the one to be blamed. I'm late this morning, and you can have all the tomatoes to me this morning. I don't know.
Sorry, there is no microphone.
There is no microphone, I hear.
There it is.
Anyway, good afternoon. It's a pleasure for me to introduce today's speakers, George Licoresos and Carmela Stevens. They both come from a very famous patent office lawyer, Carter, DeLuca and Farrell. George is a partner and joined the firm in 2002. He has a wide range of expertise in trademark, copyright, and IP protections. And he has over 20 years of experience with the IP protections. And he's been cited by Fortune 500 companies and other citations like that. Carmela Stevens also is a patent attorney with 25 years of experience, but she comes with a specialization in healthcare, and that's the reason she will assist George in the presentation. And I look forward, and as well as all the people that are present in this room, we all look forward to hearing how can we protect our creativity. Thank you, and thank you, George and Carmela, for coming.
Thank you, Dr. Amar. It's great to be here. I'll start off the presentation, and then my colleague, Dr. Carmela Stevens, will finish at the end. She'll mention, so we'll go into the agenda, and you'll see which topics I'll talk about and which topics Carmela will speak about. So I'll talk about the first three topics: the benefits and advantages of obtaining patent protection. Why do we even want to have patent protection? What are the advantages to us as a school and also to the society at large? I'll talk about pitfalls and mishaps to avoid when you're trying to get patent protection, and how to work with patent counsel to make it happen, to get your innovations and technologies protected. And then Carmela will speak about best practices to protect New York Medical College innovations and technologies, and she'll go into the patent process. And then we'll have some time for questions at the end. But if you have a question as I'm speaking, feel free to interrupt me. Benefits and advantages of obtaining patent protection. Okay, first I want to just give an explanation of what a patent is. A patent, according to the law, gives owners the right to exclude others from making, using, importing, offering for sale, or selling the invention in the United States. The word is exclude. It doesn't give you the right to make something. It gives you the right to prevent others from doing what your patent says. And we'll explain that as we get into the discussion, why that's important. And some of the items for getting patents that I'm going to be speaking about, first is the Bayh-Dole Act that was adopted in 1980. I'll explain what that did and what the act ended up, as a result of that act, how much research innovation has happened in the United States. Licensing, commercialization, and then monetization. So the Bayh-Dole Act, which was adopted in 1980, like I mentioned, was something that Congress saw was happening. They were giving out all this money to institutions to do research, but then nothing was coming out of that as far as new opportunities, companies. There was no commercialization of the technology after it was developed or innovated. So they decided to pass the Bayh-Dole Act, which gave institutions the right to retain title to any innovation or technology that was developed as a result of federal funding. So now the institutions were incentivized to do something with that innovation because they own it. So, and one of the other items that it mentioned was that the institutions must share royalties with the inventors. So that also incentivized the researchers and innovators to commercialize the technology that they're developing, because they can get royalties. And then the institutions will then reinvest the royalties back into additional scientific research and education. And as a result, since 1980, the royalty income has increased significantly to the institutions, which furthered commercialization and startups and additional capital, and then more innovation. It spurred economic growth. Another way to monetize your patent is through licensing. It enables existing companies or startups to develop the technology that was developed at the institution. You may develop a technology but not have the resources, or you want to move on to a different area of research, so you can license the IP, the intellectual property, to a company. And by licensing, it also promotes the widespread availability of your technology. It maximizes societal impacts and benefits the public, and induces additional investment and additional research in a particular technology as it develops. So when you license the technology, there's somebody on the other side who's going to then commercialize that technology. You give them a license, and then they decide to whether they want to do additional research, get an SBIR grant, or get private investment, or do a startup and develop the technology and bring it to market. And again, if it's New York Medical College's technology and innovation, that then gives the school prestige, knowing that that technology made it to the marketplace. And this little chart shows here, since 1980, when the Bayh-Dole Act was adopted, there were nearly 5,000 startups that were spun off from universities. And 3.8 million jobs have been created. And again, by commercializing the technology, incentivizes your commercial partners, the school's commercial partners, let's say big pharma or other middle market companies, to then also bring additional technology to market by partnering with the university. Other ways to monetize once you get patent protection is you can enforce your patent rights through litigation. If there's infringement and somebody is copying your technology and they haven't received a license, you can enforce it through litigation. You can also maximize your revenue from licensing agreements by giving exclusive licensing. If you want to give an exclusive license to someone, then that person or that entity will pay you more money than if it's a non-exclusive license. And one area to be careful about is we have to ensure that the technology that New York Medical College researchers develop is owned by the university. So that way it discourages other people from unlicensed use. So if the university owns and controls the technology, they can then license it and knowing that they're the owner, and they could get royalties, which they then can share back with the researchers. Some pitfalls and mishaps to avoid in the process of getting patent protection. So as of March 15, 2013, the America Invents Act was passed. That basically changed the US patent system from a first to invent system to a first to file system. Meaning that in the past, if you were the inventor of a technology, but you weren't the first to file your patent application, you can go to the patent office and show your notebook entries, your dates, any material that you had, to show that you were the first inventor, but you just happen not to be the first one to file your patent application. So that then changed when this act passed. So now it's a first to file system. So it's important to understand that if you think you have something that's novel, something that could be unique, to file your application as soon as possible, because someone else can be working in the same area and they may file first. Because now the person who files first, with some small exceptions, will be awarded the patent. And another mishap to avoid is be careful of any public disclosure. If you'll be going to a conference, if you'll be publishing a paper, that's considered public disclosure. Once you disclose your innovation to the public, you have a 1-year grace period to file your patent application. So you want to make sure that you don't start the clock ticking sooner than you want. So you want to file your application prior to any public disclosure.
So that would mean it could not be patented after 1 year if no one else had filed?
If 1 year passes, no, but you cannot file a patent application.
Could anyone?
No, no. If it's after a year and your disclosure will be considered what they call prior art to that person as well. Unless there's an improvement on that technology, they can file for the improvement. And you can also make improvements and file.
The provisional patent is suitable for also this purpose, isn't it?
Yes, good question. No, right. When you are still developing your data, you can file a provisional to get what they call a stake in the ground. And then convert that later. You have a year to convert it to a utility application. And that's something Carmela will get into. And just as a caveat, if you're not sure if it's going to be public disclosure and you want to submit something for, let's say, an SBIR grant, make sure it's marked confidential. And this is just a timeline of when is the right time to file your application, right? As it says below, it's too early once you have an idea of what you want to work on. That's too early. You still haven't developed the technology. There's no data. It's too late to file a patent application for the most part after public disclosure. You can lose your foreign patent rights once you do have a public disclosure. Like unlike the US where you get that 1 year grace period, in other countries, once you disclose, you cannot file your application. So after public disclosure, you don't want to wait that long to file your application. The just right time is after your invention has been sort of developed, there's some data, there hasn't been any public disclosure, then you can file your application. You can start off with a provisional application. And that's now Carmela's turn. Thank you. Is this your turn, right?
Okay, so I'm going to talk about how you work with patent counsel to obtain patent protection. So it starts out with a draft of a detailed invention disclosure, and the invention disclosure really serves as the basis of the patent application. And what's really important is to discuss the problem and the solution that your invention is providing to that problem. You have to, and I'll get into a little bit more detail about this, but it's really important that when you're preparing the patent application that you disclose enough information to fully enable the invention. And what enablement means is, oh, sorry. Oh, okay. What enablement actually means, and like I said, I'll talk about this in a little bit more detail, but when you say that the invention has to be enabled, it means that the patent application has to have enough detail that it teaches someone how to make and use the invention. And so that's really important, that you are able, that the invention is far enough along that you are able to provide an enabling disclosure. So you don't want to over disclose. Research that hasn't borne fruit does not need to be disclosed until enough information is known to actually or constructively reduce the invention to practice. And again, this gets to the whole enablement issue. So you really do have to be in a position where you're far enough along that you can describe how to practice the invention. Now, one thing that comes up oftentimes is that people will say, well, I haven't actually done it. I haven't actually reduced it to practice. And so to file the application, it isn't necessary that you have an actual reduction to practice, but it is important that you do have enough information that you can describe how someone would actually reduce the invention to practice. What's really important from my point of view is that, me and the inventor, work closely together. And it's important that the inventors actually contribute to this process, because it's actually the way that we get the best patent application filed. And I can tell you from experience that, I get an invention disclosure, and it's usually not that detailed, but it's enough to get started. And I prepare a draft patent application, and it's usually through the back and forth with the inventors where we really do, over time, develop a really well-written, thought-out patent application. And it has to do with preparing a draft and then being able to discuss with the inventor the actual invention. And to get the inventor also thinking about, they may have in mind what something might be useful for, but there may be other applications. And so I think it's good to have those discussions and sort of talk about future uses for the invention, for example. And the important thing to understand is that once the application is filed, that's it. So you can't amend the specification. You can't add things. You can't correct things unless it's like little typos. So it's really, really important to review the application and make sure that it's accurate and complete before it's filed. The only exception to that are the claims at the end of the patent application, and I'll get into that a little bit later, but you can actually amend the claims as you go through patent prosecution. So now I'm just going to talk about best practices to keep in mind for protecting your innovation. So for document research, it's important to keep detailed notes, identify who did what, when, and how. Entries should be, entries should be dated and signed by someone who understands but was not part of the research. So this is important for a number of reasons. One is that it's important to get inventorship correct. And so I think if you have notes documenting who did what, that when you then have a conversation with the patent attorney about who's going to be named as inventors, you can refer to your notes and say this person did that and the other researcher did this, and make a determination about inventorship. As George pointed out earlier, there used to be what were called interference proceedings, and so it used to be that it was actually the first to invent rather than the first to file who got patent protection. And so when those interference proceedings were going on, it was really, really important to have documentation about when the invention was conceived and when it was reduced to practice, so that you could submit that documentation as evidence supporting the fact that you were indeed the first to invent. So that there are no longer interference proceedings for the most part, but there are what are called derivation proceedings. And so those actually still go on. And a derivation proceeding is, let's say that you're working on an invention in your lab and you have a collaborator. This is just an example. And you're collaborating with someone, and then that collaboration sort of goes sour, and the collaborator files an application and you file an application. And so what will happen is that derivation proceedings can occur in the patent office to determine who was the inventor, and did one party derive the invention from the true inventor. And so that's why it's important to have these this documentation.
How is derivation now? This is an important point with dual application, dual research made by different investigator. How is this derivation process being implemented?
Well, actually, there have been very few up to this date that have been implemented, where there have been efforts to start derivation proceedings in the patent office. I think there's only been like 3 or 4, and they haven't actually moved forward. So there isn't a lot of information about how they would proceed. But it's just something to keep in mind. And I think when you're setting up collaborations with other entities, that it's important to have collaboration, research, sponsorship agreements in place that deal with these possible issues that might come up. Yes?
When you file under the company name, and the filing will be belongs to the owner of the company.
I'm sorry?
Can you file under the company name, or it has to be individual name?
Yeah, the inventor will usually assign to the company. So if you're working for a pharmaceutical company, there's usually an employment agreement in place that you signed when you joined the company, saying that you would assign the rights to your inventions to the company. So it's filed under your name, you're the inventor, but then you assign it to the company or whatever entity it is, maybe the college, whatever.
But if you are the owner of the company, then you file under the company name since you are the owner. It has to be under individual name.
So when you file U.S. applications, then they'll usually ask you to list the inventors and then the applicant, and the applicant could be the company that it's been assigned to. Does that answer your question? Okay. One other thing to keep in mind is to identify intellectual property of others that might have been relied on to create your invention. And so this gets to a little bit of what George was saying about how a patent doesn't give you a right to do something. It gives you a right to exclude others from doing something. And so it may be that that you're working on let's say you're working on a protein, and the protein is well known, and you make a discovery that, oh wow, nobody knew this, but this protein can be used to treat this disease. So that's very exciting. And you can file a patent covering a method of treatment using that protein. And you think, wow, that's great. But if there's somebody, an entity that has a patent covering that protein, they can prevent you from practicing that method. So it's just something to keep in mind when you're developing your technology, and especially if you have ideas of it being commercialized, that the whole idea of freedom to operate is actually important and something to keep in mind. And of course, it's very, very important to confer with patent counsel before giving presentations or publishing research. As George said, I mean, that can really affect your patent rights. Of course, in the US, you have a certain grace period, but if you're interested in filing in foreign countries, it can be deadly to actually present the data before the application is filed. And of course, from my point of view, it's always nice if we get more than a day or two notice that a patent, that a presentation is going to be given or published. Oftentimes it's, you know, just before a publication is going to come out that they think, oh my goodness, the inventor thinks maybe I should contact patent counsel and think about filing a patent application. So we always get it done somehow, but it's nice to have some extra time. So in preparing a patent application, it's important for me as the patent attorney to have a general idea of what the field is like. Is there prior art? What is the closest prior art? How are we going to distinguish our invention over that prior art? And if we can put that somehow into the patent application, or prepare it in such a way that we're, you know, distinguishing our invention from what's already been done, that's actually very helpful. And it will definitely be helpful later on when you start the prosecution process, which I'll get into in a couple of slides later. So it's important to understand what the prior art is. Usually the inventor is pretty aware of what the competitors are doing and what the prior art may be out there, but also sometimes clients will ask us to do a prior art search and just look at publications, look at the USPTO website to see what's been filed, just to get a general idea about how the application should be drafted or whether it should be drafted at all. So it is important to keep the prior art in mind, and if you're aware of it, to, you know, have a discussion with your patent attorney about it. The next thing is avoid discussing the college technology with potential partners or anyone else without first conferring with patent counsel. This avoids potential conflicts. Researchers may be unaware of the terms of agreements that may be in place with other partners. And so I think this goes back to confidentiality agreements or sponsored research agreements. It's really important to have those in place before you start talking to potential partners, just so you're not giving anything away. So now I'll just go through the patent process. And I think George talked about this, you know, what is a patent? I'm not going to actually read this, and he said it and I said it, that a patent grants a negative right, meaning the right to exclude. So I'm going to now talk about the patent process and what are the criteria for filing a patent application. what is the patent office going to look at, and what are they going to question when they actually pick up your patent application that's been filed with them, and what are they going to consider when they're determining whether you are actually entitled to the patent. So there are a couple of criteria that have to be satisfied within the patent office before they will issue a patent. So the first is that your invention has to be patentable subject matter. And so there's a list of different subject matter that are actually patentable. So for example, a process is patentable. That would be, for example, a method of treatment. That would be patentable. A machine, for example, a medical device would be patentable. Manufacture, something that's produced from raw prepared materials, so maybe plastic that's developed using a novel method that gives the plastic novel properties, that would be patentable. And then composition of matter is patentable. So that would be, for example, antibodies, cells, DNA, and I'm going to get into that in a second. There are some limitations which actually have become a bit controversial recently in the biotech field. So then those are the patentable subject matter groups. And then there's unpatentable subject matter. So for example, you can't patent a law of nature, or you can't patent a natural phenomena, or abstract ideas such as math algorithms. Sorry about that. So this, for biotech, this has actually been an area of a lot of controversy. So when I started out, which was maybe 20 years ago, more than 20 years ago, inventors were constantly discovering new proteins and cloning new genes, and you could file a patent, and you could get a patent claim covering the DNA or the protein, as long as you said that it was isolated, isolated, for example, or purified. So you could say an isolated protein, or a purified protein, or purified nucleic acid, and that was enough to take it out of just something that exists in nature, because it was purified, and that purified form doesn't exist in nature. That's no longer the case. And so if it's just simply a DNA molecule or a protein, it's very difficult to get patent protection on that. Now, I will say in this field that oftentimes, for example, with proteins, the proteins are modified, or they're genetically engineered so that they have different properties from the natural protein. And so that gets you over the 101 issue quite easily. And the same with nucleic acids, like oligonucleotides. You know, if the DNA is modified in some way that makes it more stable, there's lots of ways of getting over that 101 issue with proteins and nucleic acids. There's still a great deal of difficulty in getting patents in are claims that cover diagnostic methods. So, and I think this is a very exciting field. We were talking about it before the talk today. And the whole idea of personalized medicine has just moved forward so quickly and made so many advances. And it's become really important that there are now assays where you can look at your genetic background, you can look at gene defects, and based on those genetic tests, you can get a certain type of treatment versus another. If you have a certain genetic defect, maybe it's clear that if you get this certain drug, it's not going to work, but if you get a different one, it will work. There's, of course, tests to see whether you're predisposed to developing certain types of diseases. And so these, I think, from my point of view, are very important inventions. It takes a lot of work to discover that correlation. But unfortunately, in the patent office, it's very hard to get claims that are directed to that correlation, because the patent office says, well, that's just something that exists in nature, and so we're not going to give you a patent covering those diagnostic methods. Now, there have been recent cases that are encouraging, and there are certain certain ways that you can modify the claims so that they're more likely to go through the patent office and you might be successful. And what seems to be most successful recently is adding on an actual treatment so that you carry out the diagnostic test, and then based on that test you administer. So you're doing something, you're administering a drug. And so that seems to be something that's helpful in some way that that maybe you can get claims. But there's been a couple of Supreme Court cases that have just said that, you know, this is something that exists in nature, and we're not going to give you patents covering those diagnostic claims. And it's unfortunate. And I know that within the last 2 years, there's actually been legislative proposals to get that subject matter to become something that is patentable. So we'll see what happens. I don't think it's progressed very far so far. So these are the general patent requirements. So of course, your invention has to be useful. It has to have some use. So when everybody was sequencing DNA and there were these small sequence tags, people were trying to file patents covering all these sequence tags. And it turned out that you couldn't patent those unless you knew what they coded for. Do they have some use? So you had to describe a use. You couldn't just get patent protection on random DNA sequences. The same is true, for example, in receptors. This is another example. Maybe you clone a novel receptor. Nobody knows what it is. It hasn't been described based on its sequence, but you have no idea what the ligand is and no idea what that receptor does. So in that instance, it would be very difficult to get a patent covering that receptor, even though it's novel and new. You do have to have something that's useful, and you have to be able to describe that use.
Could you get a patent on a ligand if you discover a ligand for an orphan receptor, so to speak?
If you know what the ligand binds to and what it would be useful for.
The ligand for an orphan receptor.
Oh yeah, as long as you know what it's involved, if that its involvement in some process, cellular process. Yeah. But if you have no idea what it's useful for. Yeah. And you know, there were people that tried these tricks where, well, you can, like if you have the ligand and the receptor, maybe you can use it for screening to look for compounds that interfere with that. But if you don't know what the ligand and receptor do, you're not going to get claims to those screening methods.
You could get for screening? Can you get protection for screening? Like you get ligand and a receptor, and you're screening for an
if you know what the ligand and the so this might be I think I know where you might be going with this. So the screening, you can get a claim for the screening method if you know what the receptor and the ligand are involved in. But the next question is, well, can you get a claim to a molecule that is isolated using that screening method that you haven't actually identified yet? Maybe you have some general idea about what its structure would be, but that was a case that had to do with COX-2, for example, going back quite a ways. And if you don't know the actual structure of that molecule, and you're just describing it in general terms, that it interferes with the this interaction without having that molecule isolated, it would be very difficult. Now, to get a claim to that molecule. But let's say that you isolated 50 molecules that blocked that interaction.
That's a library.
Yeah, well, let's say that you isolated 50. And you looked at them, and they all had this structure that in common. I think that you would put into the application and try and claim those molecules having that structure, because there's enough of them, there's 50 of them, that all have that in common. And so you can describe that genus of proteins based on those common features. the question always comes up, well, you said 50, what if it's only 10? And, you know, it's just a case-by-case analysis about whether you'd be entitled to the genus claims. And of course, that's always the goal, is to get, you know, the broadest claims that you can get. But it's getting more and more difficult. The Patent Office has strict rules about written description. And so you have to be able to describe what you're trying to claim in enough detail that someone knows what it is. Of course, we talked about new, so your invention has to be novel. And then it has to be non-obvious. And so that gets, you know, it's a little tricky. When you file your patent application, the inventor picks it up and does prior art searches and will find references. And oftentimes, the patent examiner will not find a reference that specifically describes your invention. So it's novel. They will admit that it's novel, but they will put two references together that they identified and say, well, you know, someone skilled in the art, they would look at this reference and they look at this reference. They put them together and they would come up with your invention. Your invention is obvious. And so these are often the rejections that we get. And they're probably the most difficult to argue back and forth with the Patent Office about something being, whether it's obvious or not. Oftentimes you'll put in declarations from experts who will say whether something would be obvious and why it wouldn't. There are different criteria. For example, if something's obvious based on putting two references together, one question is, well, would there be a reasonable expectation of success if you combine those references? And so there are different issues that you would look at in analyzing whether something is obvious or not. I should say that in the biotech field, that the patent examiners that do pick up your case and examine them, many of them have PhDs, and so they are pretty technology savvy. But oftentimes they're under pressures to examine a patent application really quickly. So they might have 3 hours to prepare a first office action, and so they're, you know, frantically doing the searches. They may not look at the references carefully. And so a lot of times I get a first office action and I send it to the client and they're like, oh my God, what are we going to do? What are we going to say? This is terrible. But oftentimes you can find arguments for why it's not obvious. And so it just takes back and forth with the Patent Office to convince the examiner that the invention is not obvious. So this, I don't know how many of you have actually seen a patent. So on the screen there is the first page of a patent with the title, inventors, an abstract that describes the patent. The patent document is actually divided into certain sections, and so we have a background section that defines the state of art at the time of the invention and problems and limitations which the invention solves or improves. I have to say that when I started out, the background of the invention would go on for pages and pages talking about the background. And now I think it's common practice that the background of the invention is short, brief, a couple of paragraphs, because you don't want to lead the examiner on this path down to obviousness. And, you know, sometimes you can just do that without realizing it by just the way that you describe the background of the invention. And so now I think it's just short and sweet, and you don't want to do the job of the examiner. You don't want to do his job, and let him do the search and come up with what the prior art is. But it is important to say in the background of the invention what's useful about your invention and how it distinguishes over what's been done previously. And then we have the specification and drawings, and that's the real meat of the patent, where you're describing the invention in enough detail so that someone can make and use the invention. You typically have drawings, you have brief description of the drawings, and then at the very end of the patent, you have the claims. And the claims are really the most important part of the patent because that's mapping out your territory. This is what you are claiming. This is what you can prevent other people from doing. So a claim to a protein. No one else can use that protein without coming to you and getting a license, or a method of doing something, or an antibody molecule. And so the claims are really the most important part of the patent. And the language of the claims is also important. And there's like a whole, there's different ways of claiming things by saying, for example, a protein consisting of, or consisting essentially of, or consisting of. So there's different breadth of claims. And the breadth of the claims will oftentimes start out quite broad. But as you prosecute it through the patent office, the patent examiner finds prior art, references that might impact on the breadth of your claims, and so you end up making them more narrow as you go through the process. Oftentimes, a patent application will describe not just one invention, but multiple inventions. And in that case, you file your patent application, the original one, and then the patent office may pick it up and say, oh, there's more than one invention here. There's 3 inventions. There's an invention covering the protein, and then there's a second invention that is a process or a method of treatment. And so you have to pick one that you're going to move forward with in this particular application. And then you're given, you don't have to give up the other subject matter. You're given an opportunity to file what's called a divisional application to pursue the subject matter that, that the patent examiner says is, you know, a different invention. And depending on the commercial interest, oftentimes the inventions, you prosecute one case for one invention, and then you file the divisional later on, and you just keep going through the different inventions. It's not typical that, at least for me, that I have 2 patents going on at the same time on 2 inventions. But of course, if there's commercial interest, there may be a reason for prosecuting both of them at the same time. This just goes through the filing process. So you have your idea, your conception. You may or may not do a prior art search, and then you file what's called the provisional patent application. And this puts a stake in the ground. This is your date. This is your priority date. Everything goes on from that is counted from that priority date. And so you file a provisional patent application, and then you have 12 months and so the provisional application is filed. It describes the invention. It does not, you don't have to name inventor, you don't have to file a declaration, you don't have to even have claims in the provisional. And it goes to the patent office and it just sits there. So nothing happens for 12 months. And then at the end of the 12 months, you have to make the decision about whether you really think this is something that's patentable and whether you want to move forward with the application. And at that time, you file a regular patent application. And that regular patent application goes to the patent office. And it's at this point that the patent examiner will typically pick up the patent application and start reviewing it and start looking at it and do searches and come up with what's called an office action. So that's in the circle there, the patent prosecution. Prior to getting that first office action, there actually is a duty to file an information disclosure statement. And you want to do that within 3 months of the US filing. And that's so that, so the information disclosure statement is just a list of references that you're aware of, the inventor, that might impact on the patentability of your invention or something that's, you know, in related to your field. And so there's a duty actually to file an IDS and make those references known to the patent office.
Regarding this matter then of the provisional patent.
I'm sorry?
Regarding the provisional
Mm-hmm.
patent. It's rather interesting because now you're saying this doesn't even have claims in it.
Mm-hmm.
And it doesn't even so therefore it doesn't even have to perhaps have the detail of how novel it is?
Well, I actually, when I file provisionals, I think it's important to have it developed enough so that certainly if you want to establish that priority date, the provisional application has to be well enough developed that it's understood what the invention is and what the novelty is, what the how you would use the invention and practice it. You know, it could be that you file a provisional and then you file the regular application and you add a lot of new material. In that regular application, you might not be able to claim priority back to the provisional for all of that new information that you added. Does that answer your question?
Yeah, well, I'm just thinking, you know, how much protection, you're filing something which doesn't have claims, it's not as fully described.
Well, it should be fully described.
It's interesting that you still get this protection for 12 months of something that is, you know, it says provisional, it doesn't say preliminary.
No, it's provisional, and you're establishing your date, but it is based on what is in that provisional, whether you're entitled to that date. Yeah.
I think there's a lot of protection for something that's still not fully developed.
Well, in most instances, I would want the provisional application to be an invention that's, you know, fully developed in order to retain that priority date. But, you know, sometimes you don't have that. Maybe a paper is going to be published right away, and you just need to get something filed just to make sure that at least that paper, that publication has been filed with the patent office and you've established, you know, that you had that information when the provisional, before the provisional, or when the provisional was filed. So. Okay, so IDS, that's important. And within 3 months, because you really want the IDS with the references to be in front of the patent examiner when he picks up the case to prepare the first office action. So 12 months after you file the provisional, you file what's called a regular application. And up until now, we've been talking about patent applications that are filed in the United States. But of course, there's the whole rest of the world. And maybe your invention is really important and it's going to have applications in all of these different foreign countries. And so you do envision in the future that you would like to prosecute the patent in Europe or Japan or China or all these other foreign countries. It can get very, very, very expensive very quickly to prosecute your case in all of those foreign countries. And so there is a way to postpone those costs, and you can file what's called a PCT international application. And it's a PCT application, and it's referred to as an international application. And when you file that international application at the 12-month date, it actually provides you with another 18 months to decide whether you want to file in foreign countries. So you file the PCT at the 12-month date, and then 18 months later, you make the decision about whether you want to file in Europe or Japan or any other foreign countries. And that really is, it's good. It's good because it gives you an opportunity to maybe go out and see whether there's commercial interest, whether you can have a license agreement where the licensee is willing to pay the help with the patent cost, the patent prosecution cost. So having that delay is actually something that's very useful. And I might also add that at the 12-month date, you can file a regular application in the US, and you can also file a PCT. And so that's typically what's done. But you can also skip filing the regular patent application in the US, and you can file the PCT application. And then you also have 18 months to decide whether you want to file and go forward in the United States. So it really does buy you a cushion of time, like 18 months, to decide whether you're going to move forward or not.
You have to have all the claims being delineated in the PC?
You do have to have claims, yes, yes. But you get a chance to modify them. Oh, yes. So you do have to have claims in the provision, in the PCT. I mean, I always think it's a good idea to have claims. I can't think of one time that I filed a provisional application without claims, because I think it's important to have the claims to outline what the what's viewed as the invention. And then once you have those claims, then you can go back and look at your patent application and your specification and say, well, do I have support for each of those claims? Because that's what the patent examiner is going to look at when he's going to decide whether you are entitled to priority or not. Is there support for those claims? So it's, I think it's important to have claims in a PCT, and I always, not a PCT, a provisional. So I always file provisionals with claims. So then the patent, as I said, the patent prosecution goes on. It's back and forth with the patent office. They say you're not entitled to your claims. They're too broad. You're trying to cover too much. And this goes back and forth, and it's not unusual for it to go on for 3 or 4 years. One thing that actually has become quite helpful in dealing with the patent office is that they are much more open now, the patent examiners, to having interviews. So you can have a telephonic interview with the patent examiner, or you can actually go down to the patent office and meet face-to-face with the patent office, with the patent examiner, and with their supervisor if you feel like it's necessary. Sometimes you're just having these arguments back and forth with the patent examiner, and they're just not, you just feel like they're not getting it, and it's a waste of money to just keep back and forth. And so there have been instances where I've involved the patent examiner supervisor, and he always sort of acts as a referee and helps move things forward. And so it's much more easier to do that now than it used to be. So oftentimes when I get my first office action, now I will call the patent examiner and set up a telephonic interview just to make sure that we're on the same page, we understand what the invention is, and we agree with what the prior art is saying or not saying. And it seems to move the process along much more quickly. And I think this is just, we've discussed this, I think, so we can move forward. This is all just more detail. And then this just has to do with the international PCT application and just the process of going the PCT route. So I will say that when you file a PCT application, it doesn't just sit there for 18 months, and that there's an examiner that the PCT is assigned to. What is it called? An authorized, what is that person? Authorized officer. It's not called an examiner. But they are actually people on the USPTO website, unless you ask for the searches to be done in Europe, which you can do. And some people do that because the European searchers are much better. And I'm going off here a little bit, but the European searchers do a much better search job. And in some ways, I mean, you might not like the result, but it's better to find out if there is actually prior art out there that you're not aware of ahead of time. And so when you file the PCT application, it will be assigned to someone. They'll pick it up and they'll do a search, and you'll get an international search report. And then you have an opportunity to respond to the search report, which will cite references that might be relevant to your invention. You can submit what's called a response to written opinion and present your argument as to why those references aren't relevant. But that's more or less where it ends. And so the written report is there's access to it. People can read what you said about the references that were cited, but there isn't like this back and forth. It's just one report and an opportunity for you to respond. I have to say that recently, probably, well, I don't know how recent it is, within the last 10 years, clients have really not even responded to the international search report. It's good information to have, but it carries no weight really in any of the foreign countries. So after that 18 months goes by and you have to file in Japan or Europe, each of those countries have completely different patent laws. I mean, they're very similar to one another, but they have different laws about what's patentable or not. And so you can file a response to a written opinion, but in the end, you're going to file in Europe. A European patent examiner is going to pick up the case. They're going to do their own search. They're going to come up with their own office action, and you're going to respond to it. And so oftentimes now, a response isn't even filed in the PCT, and you just wait till you file in the foreign country, get an office action, and respond to it. And I guess that's it. Yes.
Can you give a current estimate of the cost in terms of environment areas for provisional versus cost?
You know, it's really, it's difficult to come up with estimates because, Pat, I know that you probably expected that kind of answer, but it is, it really is. I mean, it depends on the technology, how complicated it is. Just to keep this in mind, it also depends on the amount of information that we get from the inventor. So if we get like a short, like, you know, one-page disclosure of the invention, that's going to be really hard. It's going to take a lot of my time to go from that to a patent application. But if I get a manuscript, to work from that manuscript is so much more easier to do. And of course, it's less time. So, you know, it's difficult to say. It can be from $1,500, you know, up to $8,000. You know, it just depends on the disclosure. Yeah, for the provisional. And it depends also how developed you want the provisional to be. I mean, we can file one for less money if you want. If you have a manuscript and you want to file it with a set of claims, we can certainly do that. And then you have a year to decide whether you want to move forward and file a regular application, which, you know, then you might have more information. The specification might be developed. Hopefully, it would be developed further, and you could the cost would increase. But you have a year in between the provisional and the regular. So that's a year that you can really use to see whether there's commercial interest and whether you can license it and get help with the patent prosecution cost.
Yes, and there's a lot of interest today in repurposing of drugs that are off patent.
Mm-hmm.
People try to use it for that.
Mm-hmm.
I've been told that is difficult because since the drug is available, you may identify some new potential use for the drug. But on the other hand, the drug is there; it's generic, and anyone. Yeah, and it might have and it may have been in like an inherent property that when someone was taking that drug for one use, that they were actually maybe treating something else, and it's considered in the prior art. But a way that you might get around that, and I haven't encountered this personally, so I'm just thinking about it just out loud that, you know, if the doses are different, if the timing of administration, if the group of people that are being treated, I mean, there are different ways that you might be able to turn it into something that's patentable. Yes?
What are the auspices of the treaty, the PCT treaty? What are the auspices? United Nations? What?
180 countries. Pretty much any country you want to file in is a member of the PCT.
So, in other words, Europe is as European Union.
Yes.
All 28 countries.
Yes.
And then Japan,
Korea,
most countries.
And South Korea and Australia.
Yes, Canada.
And the United States, of course.
Yeah, most countries.
And China.
Yes. Most countries are part of the PCT.
Is there any country that's not in it that you may be interested in, or some of the clients, Argentina, Taiwan, they're not members. Yeah.
Right. Only Brazil, I think, recently. Is going to
join. Brazil.
Oh, they're a member.
Now they are, but I think for a while they weren't.
Last year they joined.
Yeah.
Yeah, and also the Middle East countries. A lot of them are coming on board.
Like
Tunisia just came on board about a year ago. But you can follow what's called the GCC, the Gulf countries, and you can include a bunch of them.
Okay,
But there are a lot of countries that come on board.
so there are 80 now.
About 180.
Okay, thank you.
And it's expensive to go in every country.
Yeah, no, of course.
Yeah, I mean, you also have to think about enforcement in that country. So, you know, you're going to file a patent in some country and there's no way of enforcing the patent. So what's the point? So those are also,
If you have a business opportunity, a potential licensee, a strategic partner.
in those foreign, yeah.
Because then, of course, after all of these preliminary things are straightened, then the safety of the product is of tremendous importance. And
But that's completely, you know, sometimes you get a rejection from the patent examiner saying, oh, well, this is like, you know, it has bad side effects. It's not going to be useful for anything. And you have to I've made arguments where, you know, you're not the FDA. So that's not your job to say that, you know, it's not completely safe or whatever. It's just to decide whether something is patentable or not. Okay.
Thank you.
Thank you, everybody.
Yes, as long as if you follow the European provisional application,
Thank you.
you have that.